Welcome to Law and Crime Live. My name is Stephanie L. Willis, and what you have just heard from the judge is that the defense has rested. We just saw William Knight, who was just on the stand, first on direct examination, then on cross, and then a redirect, and then a recross. We know that this was a we knew, or we suspected, that Mr. Knight was going to testify, and it was pretty interesting. It's pretty interesting testimony. We do have Mark Tate with us. Mark is an attorney out of Savannah, Georgia, and he has been listening to the trial with us throughout, especially throughout the testimony of William Knight. Mark, how are you today?
I'm doing well. How are you, Stephanie?
I'm well. Thanks so much for asking. So let's get right to it. One of the things that we discussed when we were off air is that we wanted to discuss on air is why would a defendant take the stand in this case? Why do you think it's important or not important in this case for a defendant to take the stand?
Well, as you know, and as we've discussed on a number of occasions, you have the right not to incriminate yourself in a criminal matter, but you also have the right to testify in your own defense. And so that's something that I think Mr. O'Brien and Ms. Palumbo would have to very carefully consider and evaluate. And I would hope that they had rehearsed his direct and prepared him for cross extremely extensively before advising him that it was a good idea to take the stand in his own defense. Sadly, in this instance, I'm not sure that Mr. Knight was completely prepared for the type of withering cross-examination that a skilled prosecutor, such as this prosecutor clearly is, can devastate him. That was a horrible cross-examination performance by Mr. Knight, and I don't see how on God's green earth that's going to help him. And my suspicion would be that Mr. O'Brien is probably concerned at this point about the cross that has come up. I think that the redirect was probably a mistake. It clearly showed and allows a jury who's unbiased to think this guy is just coming up with excuses. And I think since that was fresh to this prosecutor, he did a marvelous job of saying, hey, listen, you had the transcript. You're claiming a diabetic episode during your grand jury testimony now for the very first time in this litigation, in this criminal prosecution. And you never told us before, after you've had this transcript for months, that you had a problem. You never asked for a break. You never told us you had a problem. You never corrected your testimony. Your grand jury testimony conflicts with the testimony we've elicited here on cross and on direct, and none of it adds up. And that is the danger in letting a criminal defendant testify in his and on his own behalf in his own defense. And all of that, I mean, this is a textbook example, I think, for criminal law students and for criminal lawyers to learn how things can fall apart really, really quickly. And I think that's what happened with Mr. Knight. Also, it gave the jury a chance to evaluate him and his personality. And, from my point of view, he's a little slippery and he's a little too calm about what's going on, and the prosecutor just scored points everywhere, and he was very clever in some of the things that he said, and I think he gave us a fun preview for what I fully expect will be a great closing. And I would also just like to add in this instance, the judge, I think, did a really good job, and she recognized that the prosecutor was having a great time on the cross, and judges like to keep error out of especially murder convictions or murder trials. And she sustained every single one of Mr. O'Brien's objections. And that takes a lot of the air out of what might happen on an appeal. So she's I think, an experienced judge and is planning to put together a record that would withstand an appeal.
Right. And so we know in this case that Knight's attorneys are pursuing a self-defense argument. And we know that he told 911 dispatchers, and we know that he said on the stand himself that he feared for his son-in-law Curtis's life and his daughter Michelle, and he had no choice but to shoot Keith Johnson when he tried to flee with the dirt bike. And so we did hear testimony from Curtis Johnson earlier this afternoon stating that Keith Johnson himself had had held onto the dirt bike, or that he had gotten in the way of Keith Johnson. So it seems as if, in my point of view, that the prosecution here was able to tie him in. They had a very tactical cross-examination. They were able to tie him into his testimony. What do you think? What do you think about that?
Well, there are some very general concepts in criminal law, and one of them is that you can never use deadly force in defense of property. And I expect that we're going to hear that in the jury charge. And so the prosecutor, I think, very wisely and adeptly was able to demonstrate that if anything was going on here, it was really the deployment of deadly force in defense of property. That's what it starts to sound more like. We also know, Stephanie, in general, that one can use deadly force in defense of others if you reasonably believe that their life is in danger.
Reasonably
believe that that's exactly right. And so what the prosecutor was doing, he's so many steps ahead of where Mr. Knight is. And so I think this prosecutor, knowing full well that there will be a jury charge about when deadly force can be deployed in defense of others, demonstrated, I think, very nicely that the belief that Curtis's life was in danger simply was not a reasonable one.
I think that you brought up a great point, and that I would love for you to elaborate more on it being reasonable under the circumstances, and if you don't mind, because I think that you're doing an amazing job. So if you could just explain that a little bit more for our viewers.
Certainly. So I think that when you're analyzing whether the use of deadly force in defense of others is justified, you have to have a reasonable justification. And so what we have here is we have a man who either did or did not wrongfully get possession of a dirt bike, and we have Mr. Knight deciding he's going to become, the vigilante, and he's going to go take care of this problem and get his son-in-law's dirt bike back. And he had just gotten his concealed weapons permit, just acquired the .357 Magnum 2 weeks before the shooting, and he's seeing a situation where there is simply nothing that reasonably indicates that Curtis's life is in danger. Curtis jumped in front, maybe in front of the dirt bike as it was going away. Mr. Johnson, who unfortunately passed away as a result of this just stupid situation, was arguably trying to get away from him on 2 different occasions. And I'd just like to point out one more thing, is that I don't know any firearms training course, any self-defense course, any kind of thing doing with firearms that says it's a good idea to, quote, fire a warning shot in the air. It's just not something that's the proper use of a firearm ever. Those ballistic, bullets, when they shoot up in the air, they're going to come down. And when they come down, even just a falling bullet has been known to kill people. Right. They don't teach you, in the use of a handgun or a rifle to fire warning shots in the air. And I think that indicates clearly that Mr. Johnson knew, that there was a gun involved in this. And I think that the prosecutor, this district attorney, has and knows well what the jury charges are going to be, and absolutely pinned every element that he needs to show that there was no reasonable belief that Curtis's life was in danger, justifying Mr. Knight to shoot and kill Johnson. It just doesn't fit. And he did another, I think, clever thing, smart thing, is he showed that Mr. Knight appears to have an inability to reasonably read what's going on. And I think that came down to that video in the police station.
Right. I think that's a great point that you brought up, specifically because of the fact that initially, when we were hearing from Mr. Knight here in this case, it was also brought up the fact that his sister stated that he could be a little exaggerated at times, or even the psychologist alluded to the same thing. And so now what the prosecution did was they brought in they brought in amazing evidence of the fact that he was exaggerating or maybe lying about a certain situation when they showed that videotape of him walking into the police station and him telling his daughter, Michelle, something completely different.
Saying that the grandmother of the decedent came at him.
Right.
It was the videotape just belied that claim. And it shows that Mr. Knight is unreasonable and histrionic and exaggerates events. And I think that that's going to be really difficult, no matter how skilled O'Brien is in his closing. I just think it's going to be difficult to convince this jury in Ohio that, this man acted reasonably using deadly force to kill a man over a stupid motorcycle.
Absolutely.
And, it was a dirt bike. It's not even like it was a rare, custom motorcycle thing. You could replace it for $500 probably. It's just the whole thing is ludicrous. And I also thought, by the way, Stephanie, that some of the things that this prosecutor did show that he's really tried, I think, a number of cases and has developed some really good courtroom skills to point out that he just got his concealed weapons permit and that he had just gotten his new friends, Smith and Wesson. And that makes it look like, we got a guy out here who's, by God, going to use his new gun and take the law into his own hands. And really, that's kind of what his personality looks like to me. He was excited to have his gun. He's going to go get his motorcycle back.
Exactly. No, exactly. I think that you're exactly right, especially one of the last things that he said, as you pointed out during cross-examination, is the fact that he said, yes, you bought your friend Smith and Wesson. Were you just trying to impress your daughter? And, he really couldn't say anything. I mean, he said no, but there really wasn't much wiggle room. I think that the prosecution just did a great job in just tying him in and using his words against him. What do you think?
I think that that's true, Stephanie, and I also think it's absolutely true. And this comes, from I'm a trial lawyer, and I'm not pro-prosecution. I'm very suspicious of police overuse of force. I'm very suspicious of those things. I represent a number of civil plaintiffs when we're alleging police overuse of force, and I tell you, this smacks of those types of cases in which we have filed on behalf of victims, civil rights cases saying the police abused their force and power. This looks like a guy went in and, frequently in those civil rights cases, there is a racial element. That element is certainly present here, and so I think that this is the kind of case where a reasonable jury is going to say, this guy has his new friends. He's there to impress his daughter. He's there to avenge the son-in-law, and he's got a gun. He's shooting warning shots. He thinks this is, the Wild West, and he's just unreasonable. And he's said so many things that also tie in with the argument that he's just an unreasonable person. He's inexperienced with a firearm, and he takes one out to go get back a piece of property. And I think it's a tragic, horrible story. And frankly, if I were the Johnson family, in addition to the criminal action, I'd file a civil suit against the guy. And, I would, he may not have anything to collect, but I would absolutely file the civil suit. And it harkens back, frankly, to the O.J. Simpson trial. And he was not only criminally prosecuted, which failed for many reasons, but the families who lost their lives, they filed a civil suit and were able to show much more and collect a judgment, which ultimately bankrupted the defendant in that case. But the guy is just out of control. And if it was an officer who had shot Johnson, that officer, I think, would be charged and disciplined. And I think, obviously, the county and city would be subject to civil suit. I mean, everything about this case is really surprising to me. Did he not have a plea deal? Did he not have some way to lessen the sentence he's going to get? Right now, he's facing, as we know, the felonious assault charges. I think that's been proven. And he's facing now a murder charge. Yeah. And I think that once the jury gets the charge that you can't use deadly force in defense of property, I think he's finished. I just don't see much wiggle room for him right now.
Yeah, I do have to agree. I do know in our research here at the Law and Crime Network in regards to this case, we do know that prior to the murder charge and the felonious assault charges being made by the grand jury, when it was just involuntary manslaughter, there were, I believe, marches and protests back in Akron because the community didn't believe that the charges sufficed, and they did think that there was some sort of a racial element here in that case, which I do think that it's obvious that there was some kind of a racial element. Even I would say, and perhaps in looking at the way that Mr. Knight looked at the situation, because I do know that the prosecution during their cross-examination of Mr. Knight even brought up the fact that he added that there were 2 additional black men or black males there when there weren't.
No. That's right. I think that's certainly, it may not be overtly argued, but it's certainly a very subtle suggestion that, Mr. Knight thought that he could justify his actions by saying there were more African Americans on the scene than there were, and he thought that was and that was, in his mind, an inherently more threatening situation. That's essentially what claiming more people to be at the scene does for him. It allows him to say, I was even more threatened. So I think that's there. And I think, the grand jury, as you pointed out, did change the charges to murder. And in general, we say, the grand jury is really the rubber stamp of the prosecutor's office. But this criminal defendant testified at the grand jury. That's a little bit of an unusual situation for the defendant to testify to the grand jury. They don't have to testify there either, but he did. And again, in that instance, if I was dealing with this guy, I don't think I'd let him go talk to the grand jury. I think that we would take the fifth on everything and not subject him to that, where he's going to maybe have one of his diabetic episodes or state things incorrectly that later, can't be fixed. And remember, talking to the police when you're a target or a subject of investigation will never help you. It does not help you. You can always not say anything to begin with, and you can always change your mind later and go talk after you learn what the evidence is. It really is a game it's a game of chess. It's a strategic question of whether to talk to the people who are trying to put you in prison, and when, if you choose to talk to him, is the best time. And in criminal cases, the criminal lawyer has the right on behalf of his client to go and learn all the evidence that the prosecutor has against him. And if you're going to make a decision to make voluntary statements, it should only be made after you learn the 4 corners of the case, so that you can truthfully tell what you want to tell or say nothing. And I think in this case, he was going into a grand jury with involuntary manslaughter charges. His testimony is what ticked things up and made this a murder charge.
Well, what we're going to do now, I just want to provide a little recap for our viewers if you're just joining us on Law and Crime Live. The defense has just rested in the William Knight matter. The court has also recessed until Monday. Then we will know whether or not the prosecution will be providing a rebuttal, or if we're just going forward to jury instructions and closing arguments. What we'd like to do now is we're going to throw to a clip. It's a clip starting of Mr. Knight's testimony from earlier this afternoon, and when he first starts speaking about the incident as a whole. So take a look, and then we'll talk about that when we get back.
Does your daughter eventually get to you?
Yes, she does.
Is she still on the phone?
Yes, she is. She's quite upset.
What happens to her and the phone?
I took the phone from her and talked to the 911 operator.
What did you tell the 911 operator?
I told her my name and social security number. And I was worried. I had concerns about the police showing up in whatever direction they might, and I didn't want them to see a weapon. And
well, all right. Did you say anything else to the dispatch after your?
She asked me questions. She asked.
Wait till I ask the question.
Sorry.
Okay.
Welcome back to Law and Crime Live. If you have just joined us, please know that in the William Knight case, the the case, excuse me, is in recess. We will not be back until Monday. It will not resume until Monday, where the prosecution will either begin with its rebuttal or we will move forward with closing arguments. We still have Mark Tate with us. Mark is a criminal defense attorney out of Savannah, Georgia, and he's been with us this afternoon providing some great legal analysis for us. Mark, we just saw, you're welcome. We just saw some of Mr. Knight's testimony from earlier this afternoon when during direct examination. And now we even see, I think one of the things that you mentioned earlier was that you didn't know whether or not he was prepped very well by his attorney. And we even see that his attorney himself is getting a little frustrated because he had to ask him to allow him to finish asking his questions before Mr. Knight began speaking. Tell us or explain to us a little bit how important it is for a defendant to be prepared for these types of questions, especially when a defendant is taking the stand in this kind of a case.
Sure. Well, obviously, what we're seeing here is a witness, a criminal defendant. He's going to be nervous, no question about it. He's going to be on edge. Although Mr. Knight seems pretty calm, he seems confused. But I'm going to tell you, when we have a witness at my law firm who is absolutely critical, whether it's in a civil case or in a criminal case, and their testimony is critical and is very important in the case, we spend a huge amount of time preparing that witness. For example, we recently dealt with a Catholic Church priest abuse case, and the victim in that case, we actually brought in a witness coach. We brought in video cameras and people who posed as opposing counsel. And we acquired opposing counsel's prior examination testimony of other plaintiffs in that case. And we, on camera, put our witness through an examination and a cross-examination based on what we understood to be the prosecutors or the defense lawyers' cross-examination strategies and techniques. And we spend as much time as we need to, 2 days sometimes, going through how to respond to questions, how to do so truthfully, and make sure that they're smooth and ready to go and be the best witness they possibly can. We prepare them for their direct at trial the same way. When we have expert witnesses going to testify at trial, we spend a lot of time making sure the opinions that they're going to provide are solid and that they can do so succinctly and that they can do so accurately and do so in language that a jury will sympathize with and understand. None of it happened with Mr. Knight. Pardon me, he did not come across in a smooth, articulate, erudite kind of way of speaking. He's just not doing a great job. Either he's nervous or he's having another diabetic fit or something, but he just doesn't do much, if anything, for his own case. And I'll tell you, when he's convicted, if he can afford it, it's very possible that one of his reasons for appeal could be, as it is in many convictions, as you know, Stephanie, inadequate assistance of counsel. And sometimes that, in fact, causes a reversal in a new trial. In fact, some defense lawyers have been known to build in an ineffective assistance basis for appeal. Right. And many criminal defense lawyers will not take a case they tried on appeal simply to preserve the convict's rights with regard to claiming ineffective assistance. I don't know that we rise to that level here, but when we look at the performance on direct and the decision to let him testify and the redirect in which he for the first time claimed that he was having a diabetic fit during grand jury testimony, so he didn't know that he was not being accurate, these things tend to start to add up in a trial like this.
Well, I have to kind of stop you there for a second, because it seemed to me as if his attorney led him into responding in that type of way, because it was the defense attorney who actually brought up the diabetic episode, and I believe the defense attorney mentioned the grand jury. So what's up with that?
It's hard to look in. We talk about when we try cases, there's essentially three different cases that we try. There's the case we want to try, the case we think we tried, and the case we actually tried.
Right.
And sometimes you get a little mid-trial amnesia about what you want to do, and that can happen to the absolute best lawyers. And so, yeah, maybe he just lost his footing. I don't know. It's hard to be critical of somebody, when they're in the moment.
Right.
And, we're sitting back here, the armchair quarterback saying, why would you do this? How could you do that? But this is a case to me that, Mr. Knight really brought on himself. The community was outraged at the charges that were first brought. They made that known. This is a hot button case. I mean, I think he should have been working to not go to trial and instead work out some kind of sentence that might make it so he gets, out of prison before he dies. He's 64 years old. He's going to be facing a long sentence after he's convicted.
And we do know in this case, the jurors, we have a makeup of seven males, 6 Caucasian, 1 African American, 5 females, 4 Caucasian, 1 African American, and two male alternates and 1 female alternate. We do know that voir dire is very, very, very important. But I kind of want to scale back just a little bit regarding, I believe it was yesterday, there was a psychiatrist who came on the stand and testified as to Mr. Knight and exactly how he grew up. There was a lot of testimony that was brought in about his abuse and her perception of him, whether or not he was a very smart individual. I want you to talk to us a little bit about, and I know that we are not in the minds of the jurors or the members of the jury, but talk to us a little bit about how you think that makeup of 7 males and 5 females and how that testimony might affect them, if any.
Yeah, well, I mean, obviously that's something that was designed to engender some kind of sympathy. He was abused. Unfortunately, a lot of children are abused, and I don't think that justifies murder. But you got 7 guys on there. You have 2 African Americans on there. These guys, I'm sure the defense lawyers and the prosecutors conducted a thorough and sifting voir dire trying to figure out what kind of juror they want on the case. I think that juror makeup may, with 7 men on the jury, it may tend to make them more sympathetic to Mr. Knight. But you got to come back to the evidence, and you got to come back to the fact that each one of these jurors has sworn an oath and sworn that they are unbiased and that they can listen to the testimony, and they don't have any preconceived notions about who is innocent and who is guilty, that they don't have any problem with convicting somebody of murder. And so when you have those people, and jurors in my experience take their oaths very, very seriously, and they work very hard to get, at the right result. And so I think that given this man's testimony, regardless of, the psychiatric experts saying, maybe he's not very bright, maybe he was abused, maybe he had a bad upbringing, and we just showed the picture of the little bitty dirt bike that we were worried about. Right. And this caused this man to come after somebody brandishing a pistol. It's just, I see no way that anything that happened in this man's past makes it so he's going to lie about the number of people who were at the scene. He's demonstrated unreasonability by claiming that the grandmother came at him in a police station and the deputies, at least impliedly, had to subdue her to make it so that he was shooting warning shots, and that's okay, and that he actually shot a man trying to get away from him on a little bitty dirt bike. He just isn't reasonable in any way. And, I don't believe that, this kind of jury, regardless of makeup, is going to acquit him. Now, an acquittal would, of course, be the best result for a defendant, but the makeup, it has to be a unanimous verdict.
Right.
And it could be somebody on there who won't go guilty and can hang this jury. We see that sometimes. I don't know.
We've seen that a lot, actually, on the Law&Crime Network.
Yeah.
Unfortunately, we have seen that a lot. What we're going to do is we're going to switch gears from his direct examination to cross-examination by the prosecution. We're talking about William Knight, who's on the stand in the prosecution's cross-examination. And so we'll take you to that clip where he's discussing whether or not Curtis was there and whether he offered his truck to Curtis that day. So take a look at that clip, and then we'll be back once the clip is over.
Okay. Would you agree with me that you were mistaken?
I was overwhelmed by fear at that time. I might have been.
Okay. So tell me, from pulling behind Kurt's truck and being completely calm with no issues to going up, making a U-turn, parking, to be overwhelmed with fear?
There was arguments going on. Michelle told him, if I'm not mistaken, told 911 that they're getting aggressive with my husband, and this all started taking off.
Now, that you had told us on direct examination that you couldn't really hear what the words were, but you were able to hear your daughter's words.
I could hear Kurt tell her at one point, and I think she'd already called 911, but I heard him at one point tell her to back up and call 911.
All right.
I heard that, and then I heard her comment.
All right, and you heard her on the phone talking calmly on the 911 call, correct?
I heard her. She come up and got away from him. She backed up like he told her at this first point.
And she backed up.
She came up this way.
What's up this way mean?
Toward the dead end. She backed up when he told her to back up.
And welcome back. We're looking at testimony from Mr. Knight's cross-examination, from earlier this afternoon. We still have Mark Tate with us. Mark is a criminal defense attorney out of Savannah, Georgia. Mark, we see from this clip that we last showed, we're seeing now how the prosecution is now starting to lay out, I guess, their opinion through Mr. Knight's words that he was not reasonable in his fear. Can you talk to us a little bit about that and how the prosecution accurately laid that out for the members of the jury?
Well, he's made him say that he could hear not their words, but he was interpreting their tone. And that lays some groundwork that the prosecutor brings out later. And we hear that he's in a state of panic and fear at that point. He has overestimated the crowd. He's now admitted that because he was so scared, he didn't know how many people were there. It just is really painting a good picture that the prosecution now will be able to argue in closing arguments that Mr. Knight simply was unreasonable in his interpretation of the circumstances. And, being dumb is not a defense. It's just not a defense unless you're so dumb you're incompetent. Right. He has not been declared incompetent. So he's just making him look like he could not accurately interpret a situation. And I think that's good, because you remember, and you got to remember that, folks who are in law enforcement are routinely trained to be able to interpret accurately what's going on in high intensity situations. And this man is clearly unable to do so in any regard. And so the prosecutor is beginning to sew the tapestry that he can argue from in closing to show that the man's unreasonable and that he intended to kill this guy. And again, that he showed up with his new friends, Smith and Wesson, the prosecutor's own words, which are a little bit inflammatory for a cross. And I'm surprised maybe that there wasn't an objection to it. But you got to remember, Stephanie, that in closing argument, the lawyers are permitted, and it's 100% expected that they will draw any reasonable inference they can from the evidence that has been admitted. Right. And it really is an argument, and it's the opportunity for the defense counsel and for the prosecutors to draw all the inferences from all of this evidence that they put on before this jury for the last days of this trial. And so, go ahead, I'm sorry.
No, go ahead, I'm sorry.
I was just going to say the prosecutor here has laid beautiful groundwork throughout this cross-examination to show all of these things that you and I are talking about now. And there won't be any ability to object to it, because the things that you and I are discussing, that we're concluding from the evidence that we're seeing, those are all reasonable inferences that this prosecutor is going to be able to stand up and tell the jury. And he'll be able to argue very persuasively that Mr. Knight was unreasonable, that he's using deadly force to defend property, that he shouldn't have gotten involved in this, that he was not skilled with a firearm, which is unreasonable to start wielding a firearm if you're not trained in it. I think that Mr. Knight, I think it's good night for Mr. Knight.
We can tell that you're a criminal defense attorney. You have got those catchphrases down packed. What I wanted to say was that, I think that the judge gave both the prosecution and the defense here a gift in allowing them the weekend to prepare their closing arguments, because I can recall myself as a former prosecutor. I practiced in New Orleans, and when it was time see, you're laughing, you already know. When it was time to go to trial, the judge was like, just be prepared for closing arguments. We really didn't get that much of a break, maybe half an hour, 45 minutes tops. What's your experience with that?
Yeah. One of the very first civil cases that I tried was in Pine Bluff, Arkansas, and it was a negligent road design case, and the firm defending the case was actually Hillary Clinton's old firm.
Wow. And
so that was sort of fun. But we were approaching the beginning of duck season, and the plaintiffs had just rested our case. And the judge said, fellas, duck season starts, this evening, and I'm going to allow each of you 30 minutes in closing argument and 30 minutes to prepare. And we went. And, what I learned from that is that it's sort of insulting to the jurors' intelligence to go back through and remind them of all of the evidence that they just sat through.
Right.
And so I think that many times the most effective closing arguments are ones that come on the heels of the close of evidence, because you can get in, you're forced to prepare quickly, you pick out the most important things that there are to you to highlight to the jury. The juries don't want to hear a recap of every single thing they've heard. They want to hear what you as the lawyer thinks, what facts you think are important that will drive them to make a unanimous decision. And you've got to, it's your chance to argue. And so you've got to decide, what are my strongest points to argue to this jury, and go with it. And I think allowing the prosecution to have the weekend to decide whether there's going to be any rebuttal evidence, and allowing the defense counsel the weekend to prepare with how they're going to dig out from the hole that we got put in, I think you're right. I think that's a huge gift. And as I mentioned before, from my observations of this judge, I like her. I think she's a fair judge. And, I think probably she's looking down the line about the appeal of this case and wants to make sure there's no allegations of impropriety or unfairness. And I think she's really trying to build in an appeal-proof verdict.
Well, we're going to continue replaying the clips from earlier from William Knight's testimony. We're going to continue on with his cross-examination by the prosecution here. And what we're going to do is we're going to continue on with the cross-examination and from what Mr. Knight perceived at the time. So take a look, and we'll be back with Mark when we get back.
Just answer my questions.
Yes, sir.
You'll have an opportunity. Mr. O'Brien's going to get a chance to get up. You can say whatever you want to say to this jury. Okay?
Yes, sir.
You're sitting in your truck, take down license plate. You are in fear.
Yes, sir. Somewhat.
Okay? Somewhat.
Yeah.
And you still have the phone in your pocket.
I don't have a phone on my mind. There's too much going on.
You don't think about calling the police?
I don't see where it's going to help. Michelle's already talking to 911, and from what I've seen is going on, there's probably people called 911 before I got there, sir.
So you were just assuming that?
Yes, I was assuming that.
All right. And you didn't think it might just be,
The lucky
a
call.
little cautious to go ahead and call anyway? Yes? No?
There was this argument's ramping up too rapidly to realistically believe I'm going to make a difference making a 911 call when I see Michelle's on the phone.
Welcome back to the Law&Crime Network, where we are still looking at clips from earlier testimony from William Knight. We are looking at his cross-examination, and we still have criminal defense attorney Mark Tate with us out of Savannah, Georgia. Mark, what did you take from the last clip that you saw? I mean, we see that his demeanor is still very calm, but yet there were some objections that were made only because the judge did sustain them, only because she said that some of the questions were circular, and that she wanted the questioning to keep moving. But are we seeing that the prosecution is pretty much, tying him down is essentially what I want to say?
I think that he's I don't know if he's tying him down as to his testimony, but he's tying him down as to his ability to interpret what's going on,
right.
Definitely. He goes from they're arguing to they're shouting. I'm in extreme fear sitting in my truck. No, I wasn't in extreme fear then. I was in extreme fear when I got out of the truck. So, and he uses such, Mr. Knight, that is, uses such superlatives in describing what he sees going on, and that he disagrees with every witness, and that's a really effective cross-examination technique. And we see it. It's the old thing of, are you lying now, or were you lying then? Mm-hmm. And so to have this witness be able to say, my point of view is different from what every other witness has to say. The prosecutor's doing a couple of things. He's showing him to be, again, unable to accurately interpret and reasonably interpret what's going on, but he's also showing that he may lack credibility. And it's a two-pronged attack. Not only were you unable to understand what's happening around you, but you are also unreliable. And your testimony, if you're not intentionally lying, then you're so unable to relate what's true that you have no credibility. So right. I think Mr. Knight's credibility is in the gutter, and I think that no good has been done for his defense by letting him get up there and meander and wander and agree to things like, everybody else disagrees with me, so they're all wrong. And again, this prosecutor is using this cross-examination to build the foundation for what I think is going to be a really fun closing argument to watch.
I just think it's kind of funny, though, because the defense, obviously, or the defendant, in this case, has the opportunity to listen to the testimony of everyone before he took the stand, and yet he was set on just, sticking to what he perceived to be a reality. Doesn't that go back to the reasonableness or the unreasonableness of the situation?
Yeah, and Stephanie, you are a prosecutor in New Orleans, Louisiana, right? Mm-hmm. So people are. It's known for the crafty responses that people can generate.
Yes,
and it's a challenging place because there's always a fix afoot, right?
Yes,
there's always a lagniappe, and so you never know exactly what's going to come at you. But I think you're exactly right that this witness is demonstrating that his actions weren't reasonable, and. We come back to the question of, when I'd love to get Mr. O'Brien and talk to him and say, listen, have him comment on why let this guy testify. Mm-hmm. And don't forget, the defendant can absolutely insist that he testify. And that may be the situation. He may have said, I want to get up and explain this. Is he pretending to be more pitiful and ill-equipped to function as is this true? Is this really the way he is? I don't know. I mean, to me, watching him, he's a pretty pitiful lad.
Well, we're going to continue on with replaying some of the clips from Mr. Knight's testimony, just so that our viewers can get recapped, and in case that you missed anything, so that you're all caught up once trial resumes again on Monday. So we're going to continue on with the clips, and hopefully Mark will be able to stay with us just a little bit longer so that he continue providing us with some great legal analysis. Stay tuned.
Now, this is you coming off the elevator here.
I see that.
Okay? And she is standing up.
Yes, she was.
All right? And when she sees you, she actually turns away from you, doesn't she?
She turned directly at me first.
Now, she didn't jump up,
Yeah.
did she?
No.
Watch your feet, Mr. Knight.
I'm watching.
Her feet never even moved, did she? Did they?
No.
She doesn't
Not
do.
much.
She doesn't do one thing, does she?
No. Not from what I'm seeing here.
And then you refer and tell your daughter that you had a couple deputies behind you to deal with what was ever going on behind you, right?
But from what I'm seeing, I don't even know if I could have seen her face here, but I knew it was her.
The deputies don't even seem to notice her, and yet you're giving your daughter the impression that Keith Johnson's grandmother jumped up, came at you, and the deputies had to do something to restrain her, basically, from getting to you.
No, I didn't say they had to restrain her.
You implied it by saying the deputies dealt with it behind you, right?
The deputies could deal with.
All right. She jumped up and came at me, or started at me. Did she do that?
No, she didn't.
So why in the world are you telling your daughter that?
I didn't mean that.
Welcome back. This was a great clip that we last saw with the prosecution using both video evidence as well as testimonial evidence, of Mr. Knight's conversation with his daughter. And we still have Mark with us. Mark, I know this was one of the first things that we talked about when we first got on the air. So I know that we don't have you on for much longer, but I wanted to thank you so much for being with us today.
Thank you.
Your final thoughts on this case. What do you think? Based on how it's going, what do you think is the outcome of the result?
Well, I think he's going to be convicted of murder, and he's going to be convicted of felonious assault. And again, the clip we just watched, Stephanie, showed very clearly that Mr. Knight over-exaggerates and is histrionic in his statements, and that little scenario just concocted by the prosecutor, where he took Mr. Knight's words, which are very similar to words he uses to describe what the decedent did, coming at him when it did not happen. And we have a beautiful argument for parallelism for, we don't have video of what happened to Mr. Johnson, but Mr. Knight said the precise same thing about Mr. Johnson's grandmother coming at him and having to be restrained as what he accuses Mr. Johnson, who he killed, of doing. And it just shows his lack of ability to be reasonable in understanding circumstances in which he finds himself. And so I think that's going to be sort of the end of it. I don't see that a jury is going to be deliberating very long. I would expect we're going to see closing arguments, and the jury will get the charge. They'll elect a foreman, and I expect a verdict pretty quickly in the case. I could be wrong, but that's what I'm thinking.
Well, yeah, we never know with members of the jury because we don't know which way they're going to go. And, that's one of the good things about having a jury, because we leave it in their hands to ultimately decide the fate of the defendant. And so, Mark, we want to thank you so much for being with us this afternoon, and we'd love to have you back here on Law and Crime Live. Thanks so much.
Absolutely my pleasure. Thank you, Stephanie.
Thank you. And so we just want to, again, reiterate the fact that this case, Ohio versus William Knight, will resume again on Monday morning. We're not sure whether or not the prosecution will begin with rebuttal or if we'll be proceeding forward with closing arguments. We do want to let you know, however, that next week we will resume with the Georgia versus Tex MacGyver case. And we do know that that was a case that all of you loved watching, and we loved watching it here on Law and Crime Live as well. And so make sure that you you tune in on Monday so that you can continue to watch the Georgia versus Tex MacGyver case. What we're going to do right now is I'm going to show you one of the last clips from the cross-examination by the prosecution, because I just thought it was just a wonderful way for the prosecution, or the prosecutor, in this case, to tie everything together before ending his cross-examination. So take a look at that, and then I'll see you when we get back.